This is the Department of Children and Families.
Good morning, Your Honors. May it please the Court, Colbert on behalf of the Regional Counsel's Office, representing the father, H.S., in a termination of parental rights case from the 11th Judicial Circuit. I'd ask to reserve 2 minutes.
All right.
Your Honors, this is a termination of parental rights case where the father's rights were terminated solely on the basis of abandonment, 39806-1B, which in turn refers to 39011. This is a case where the trial court applied a double standard. It terminated the father's parental rights based on abandonment because of his failure to communicate from Haiti, from post-earthquake Haiti, with the department and or his child, but at the same time it waived the department's responsibility where for 8 months the department was unable to communicate or to serve this father because of the inability to contact people down in Haiti, and that was actually prior to the earthquake.
Isn't it different? The department has 4,000 people that it's seeking to find, but your client has only one kid.
But there's no record evidence that he even knew the child existed, Your Honor. The only record evidence is a transcript on page 23, I believe it is, 23, where he states that somebody contacted him about the court case. He didn't know who contacted him. He didn't know when he was contacted. He just knows he was contacted.
He had no idea that he was the father of a child?
There's no testimony that he was, Your Honor. There's no evidence that he knew it prior to the court case. Prior to his first contact with anybody was November of 2009.
He had some contact with the mother, I assume.
There's nothing in the record that says that.
Well, he's the father of the child. He had some contact with the mother at one point.
Well, quite obviously that's true. And in fact, he said he had a relationship with her from 2 years previously. She was here in Florida. He was in Haiti during these proceedings. She lived here in Florida. So the record, again, is absent as to evidence regarding any contact with anyone. The first contact anybody had with this father was November of 2009. The department sent down 2 affidavits, one of paternity, one of non-paternity. The only evidence before the trial court was the father's testimony that some gentleman came to him, gave him 2 documents in English. He asked what they were. He was told it would be in his best interest to sign them. It had to do with his daughter, his child. And he signed both of them, the affidavit of paternity and non-paternity. The gentleman took the documents back from him.
So when the department or the guardian says that the father didn't utilize either form of communication, that is letters or a telephone, to inquire or communicate with the child, and that he did this despite knowing that the child was in state care, he admitted to communicating with the mother while she was in Haiti, and the court permissibly credited the testimony of the case manager that the father had the department's contact information as early as November 2009. That's not correct?
That's not correct. If you look at the record evidence in the testimony, Your Honor, when the cross-examination occurred, he admitted that those 2 documents were provided to the father, but there was no other document that, and in fact those documents were...
This is a
2 documents.
very serious matter, that you're saying that the statements, which are blanket statements of the guardian ad litem, are not correct.
The only testimony was as to the father, that he received those 2 documents and gave them back to the gentleman in English, which he didn't understand, signed them and gave them back to the gentleman. They were not left with him.
The only contact that the Department of Children and Families ever had with this father was to serve papers on him, correct?
That's correct.
Never contacted the father before serving the papers and never contacted the father after the serving the papers.
Absolutely correct.
And everybody who's testified that the parental rights should be terminated, not one of them has even spoken to the father.
That's absolutely correct.
And the one person who says not is the one who has seen the father, correct? Ms. Vanellen is the only one who says that parental rights should not be terminated, and she's the only one who's seen the father.
Right. She was a friend of the family's.
Was there a requirement prior to the filing of the petition, any requirement that the father be notified of the dependency or anything of that nature?
I believe there should be, yes, absolutely should be.
Maybe there should be. Is there any legal requirement that he be notified or notice attempted to be given to the father of the mother's dependency, any legal requirement.
There's no statute under dependency that requires that the father be noticed.
When the petition was served on the father, is that the time when the two affidavits were also served on the father, or were two different times?
Two different times. The affidavits were served in November. The father was not served with the petition. The amended petition was not done until June of 2000.
In an abandonment situation, is it required that there be a petition for dependency first filed, or can you go straight to termination?
Yes, there has to be. Are you asking does there have to be a case before there can be abandonment?
Can there be is there a legal requirement that there be a dependency before abandonment?
Yes, I believe there would be, because moreover, I think
whatever the answer to that question may be, is there a requirement if you go straight to termination, which you can do under certain circumstances, is there any requirement that there be a case plan or performance agreement provided to the father?
No, there's absolutely the ability for the department.
If either parent has abandoned the child for 5 years, never been heard of, you can directly terminate that parental rights without filing anything at first, can you not?
Absolutely. You can file an expedited TPR, but, Your Honor,
the basis of it is that there's been a factual abandonment.
But there's no record evidence this father even knew he had his child.
There has to be an ability. There has to be an ability to support, and there has to be some evidence of communication, correct?
3901.
How much did this fellow make down there?
I think he said 40 gourds a day.
And that's a couple dollars.
Something like that. I believe it was approximately $1. Actually, he said he made 20. He gave us a range.
And he said that he could not support the child on that, correct?
No, he said he'd be able to take care of his child. He
said he'd have a room because he was living with his mother.
Right. Exactly. Well, as the Great Depression has taught us all,
where did the father have to go in order to get the mail?
The record is unclear. I don't know where he would have to go, but what I'm saying to this court is he
lived in Laganes, right?
Sir?
He lived in Laganes.
Correct.
And in order to pick up his mail, he had to go to Port-au-Prince, right?
I would guess, but I don't know the logistics of that, Your Honor. But under 3901, it says, while being able, as regards to communication and support. The argument before this court is that the father was not able. How could he communicate with a child he didn't even know he had?
He could have sent a letter.
He didn't even know he had it. He didn't even know he had it.
He could have sent letters, okay? Maybe he couldn't support it, but he could have sent letters.
Your Honor, he did not. What I'm arguing to this court, what I'm telling this court is on the record, there's no evidence he even knew he had a child until November of 2009. For the first 8 months
between November 2009 and time of termination, how many letters did he send?
He sent one, right before the end. But again, he has to have the ability. This is post-earthquake Haiti. Nobody testified they communicated with him. He said he had no idea where to send a letter or who to send it to. Nobody communicated with his father for the entirety of this case. They served him 2 different times. They served him once in November with the affidavit of paternity and non-paternity in English, which he had no idea what it was. They served him again in June of 2010 with his petition for termination of parental rights and his summons.
Mr. Colbert, let's hear from the department.
May it please the court, Karla Perkins on behalf of the department with Hillary Kambour for the Guardian Program. The facts in this case actually go back to before the earthquake in Haiti. This little girl was born on February 22 of 2009. The earthquake in Haiti did not occur until January 12th of 2010. And when we go to page 20 of the transcript, the father was asked, "Can you tell me one thing that you do know physically about your child?" His response was, "I know that my child was born and I know that she's under the state's care." He also testified to seeing the mom 5 months before trial. He also testified to having a number of relatives here in Miami. And
he made no contact. There was no contact between him and the child between the time the child was born and the time of the earthquake, correct?
The time of the trial, when he had a witness on his behalf, Ms. Fenelon, who came in and testified.
Who brought back a letter.
Who wrote a letter and a picture of the father.
Well, he did in fact try to contact the DCF to find out about the child and could not get a response, correct?
Well, he testified that he tried to call, but the fact was when he was sent those documents, and remember, at the time that he was sent the documents in November of 2010, he was only prospective father because there was no name on the birth certificate of the child.
Was he sent those documents before the petition was served on him?
Absolutely.
Okay, and then the petition was served, correct?
Well, actually, if I can...
The petition was served after he signed the paternity documents, correct?
He signed 2 documents. And what happened was when we received back those...
Miss Perkins, the petition was served on him after he signed the documents, correct?
Correct.
Was a case plan or performance agreement ever served on him, ever given to him?
He was not given a case plan based on the fact that...
Was he required to be given a case plan or performance agreement?
Not on the grounds of abandonment.
There's no legal requirement.
Not
All you have to do is have the petition served on you. Is that accurate?
We can serve a termination petition on him on the ground of abandonment.
Yes. Is there any requirement beyond that the department serve anything else on him, such as a case plan or performance agreement?
We're not required to give him a case plan when we're going on grounds of abandonment.
There was one prepared in this case, correct? A case plan, a termination case plan, correct?
Well, remember we were working with the mom also.
No, am I correct?
There was a case plan, but not for the father.
Was there not a case plan prepared in November of 2009 at the exact time the petition was filed and served on the father, for the mother and the father?
The case plan was not a reunification case plan with the father.
There was such a plan, correct, Ms. Perkins? It was prepared.
There was a plan because the case plan has to be in effect at all times. The case plan really...
What is the purpose of it if it just goes in the file?
A case plan travels under the child. We have to make sure the child is receiving. So when we have tasks...
Well, why does it have tasks for the father?
There were no tasks. Remember, in November 2009, he was not the legal father of the child. You're traveling on the fact that he was the legal father of the child in November 2009. He was not. He signed 2 affidavits. When did he sign those affidavits? He signed in November 2009. He was provided with 2 affidavits, one of non-paternity and one of paternity.
And he signed those before...
He signed both.
He signed both before the petition was filed on November 11th, correct?
The petition that was filed on November 11th was not a petition against him.
Are you certain of that?
The petition filed on November... The record reflects he signed the non-paternity and paternity affidavits on November 10, 2009.
Well, the fact of the matter is that through all of this, the department never made any effort to contact him, correct? Either before or after the filing of the petition, correct?
That's not correct. Respectfully, the department disagrees.
When?
We sent...
When?
Judge.
Other than the filing of the petition, when did the department contact him?
We sent him, I have to clarify this, because what happened was when he was sent both affidavits, where he signed a non-paternity and the paternity affidavit, we could not establish him as the legal father at the time. Other than giving him,
Ms. Perkins, other than giving him legal papers, did the department ever contact him?
There is no record evidence.
There was never any individual or personal contact, correct?
Correct.
And what was he to do? He tried to call, correct? According to the record, he said he did.
He said he tried to call, but remember
there was no evidence of anybody in the United States receiving such a call.
Absolutely correct, Judge.
And the Florida Department of Children and Families does not record incoming calls, does it, at the switchboard?
I could not answer that, but that's not in the record.
Counsel, does this child qualify for a permanent guardianship?
Does a child qualify for a permanent guardianship? Based on the age of the child, number one. Number two, the fact is, if the court has a ground...
You may answer the question yes or no, and then explain your answer.
Based on the child's age, we prefer not to put a child's age...
Not prefer, but one of the requirements for termination is that it's the least restrictive means, correct?
Correct.
This particular one went straight to adoption. I mean, that's what the case plan says, the November 09 case plan. Did this child statutorily and legally qualify for consideration for permanent guardianship?
We have the goals
for consideration.
Judge, at that point in time, no. Because number one, we have preference and goals. We are required that if we can't reunite the child with a parent, then the next permanent goal has to be adoption. If that is not feasible, then you go to permanent guardianship or placement with a relative. Now, for us to put a child who was born in 2009 in a permanent guardianship, number one, the court forgets that we were dealing with the mom before we were dealing with the father. We did not establish the legal father, this appellant, as the legal father of the child until 2010. So you're traveling on a basis that we were dealing with this man in a bad way from all along.
I'm not traveling on any basis, Ms. Perkins. I'm asking questions, and I just want answers from the department. That's all I'm asking. Ms. Perkins, does a father who has a child in the United States who happens to be a United States citizen, does that child have any preference, let us say, under the United States immigration laws to get to the United States, get admission to the United States?
I can't speak to immigration laws.
Is that the type of service that let's say if this father were in Canada, the department might look into or suggest? Has that ever happened?
I'm pretty sure we've placed children with parents outside the U.S.
Yes, there's nothing wrong with it once you've done all of the work, okay? Might be Canada, might be Haiti, and there's no prohibition. Well, I suppose, in some terrible countries maybe you wouldn't, but there's no prohibition on placing somebody in Haiti, correct?
Correct.
Now, would not a service to this individual have been one way or another, either through DCF or through perhaps the lawyer for HS, offering the service that you will refer the person to some legal clinic or lawyer who might assist?
I thought that the interests of the DCF were with the child, and that the father and both parents have not only have rights but also have responsibilities, and one of them is to contact one's own child on his own. The parent is not supposed to need the assistance of the DCF to get into the country and to get the rights affirmatively offered to him. He is supposed to exercise them, and if he doesn't, under the law, it's an abandonment. And under the law, an abandonment leads to a determination of his whatever parental rights he has. Do you agree with any of those statements?
I agree with every one of those
statements. And the department has no obligation, once it files a petition for termination and decides it's going to go that route because the goal is adoption, but that's the road that they're on. No adoption provides the contact or provide any services whatsoever to somebody like Mr. H.S. Correct?
He has to ask for them, doesn't he?
It's not correct because it's only when you have certain grounds for termination that a case plan is not required. If the father had been around, if he had contacted his child, if he had maintained, remember,
he had a lawyer. He had a lawyer.
He got a lawyer appointed in court before he was actually found by the court to be the legal father of the child. So during the time
so that service was provided
before he was established as the legal father.
And that's the only service that was provided.
Judge, that's not the only service provided to this father. The fact is, from February of 2009, when his child was born, the transcript reflects he knew that his child was born.
Yes.
He knew, but what did he do during the time span?
What was he able to do, counsel?
He testified that he was working before the earthquake. So he did testify. He testified that he lost his job.
Did he say that their testimony had the ability to send any of that $2 up to the United States?
That's post-earthquake employment. He testified, I found a little job. And then he testified he can make 40 gourds up to 100, which is $1 to $2 a day based on his counsel's.
Thank you, Ms. Perkins. Mr. Colbert, you asked for 2 minutes. That's what you have.
Briefly, to address the court's previous question.
The fact of the matter is, this father didn't make any effort to speak of to contact his child, correct?
He did not know where this child was. He did not know who to contact.
He had a lawyer.
Not until January of 2010, Your Honor.
And that was 11 months before the termination.
It was actually September was the termination, and I would point out to the court that he was not, the argument that he was not adjudicated the legal father. He was adjudicated the legal father 2 weeks after they filed the amended TPR petition. You were right in saying...
The termination proceeding went on for a full 12 months, correct?
It started in February of 2009.
And the only time that he sent anything to this child was the weekend before.
That's correct, Your Honor. But
he did inquire about the child through his lawyer, correct?
Yes.
And he testified that he tried to call the department.
He tried, but how could he contact the child? How could he contact the department when they never reached out to him? You're right.
Well, there's a phone book.
Don't try.
There's a phone book.
In Haiti? I don't think the calling out of the Nivas to here would be such an easy matter, Your Honor. But again, that's not before the court. There's no record evidence. Only record evidence is the father said he tried. They never contacted him. They never gave him...
He had internet access available, correct?
I don't know if this father's literate. He had a 9th grade education. I don't know what ability this father had.
He wrote a letter.
He wrote a letter in English. So somebody obviously wrote it for him.
All right. Thank you, sir.
You're welcome.